So we're going to continue a conversation on international organizations, international law, and global governance. And we'll begin by looking at where international law comes from. International law is different than what we see sort of domestically within states. Typically within a country, there's maybe only one or two different sources that are able to create law, Congress or a parliament or something like that. But within the international system, there's a variety of different ways in which international law can come about. So one of the ways international law comes about is through international treaties or conventions, right? So these are codified rules, codified legal statements about the relationships between states. So states will come together and they will negotiate a treaty about how information will be shared and when they will notify each other of different things, right? So you could have an information sharing treaty governing intelligence sharing. There can also be conventions where a large group of states come together and they develop a document that will hold for the entire international system. And the idea typically with treaties and convention is that they're going to be binding, that they are legally enforceable rules pending ratification, that a state signs on to these things. That will help direct and guide the relationships between states. And that's a major source of international law. It should also be noted that treaties tend to be binding on states that ratify them because they are agreements between those states, whereas conventions are general statements about how the international system should be operating and can be considered to be international law and binding even for states that didn't necessarily sign on to these agreements. And so an example of this would be the International Criminal Court, which was created by the Rome Statute, which had a threshold for coming into effect of, I think it was like 120 countries had to sign and ratify the agreement for it to come into effect. And the International Criminal Court potentially has jurisdiction over countries that didn't sign and ratify the Rome Statute. There's a process for that to happen, but the idea is that once you have sort of a central consensus within the international community, that those agreements then sort of have the full force of international law for everybody. There's also international custom, and historically this was the primary source of international law. Today, most international law gets made through treaties and conventions and gets codified, but historically, international law emerged from the patterns of interactions between states that became so routinized and so expected that they became law-like. And there's a particular term, opinio juris, a Latin phrase, which essentially means that I believe that I am obligated to act in a certain way by these norms and conventions. And if states believe that they're obligated to act in such a way, that essentially means that it has the force of law. And so lots of things like diplomatic immunity were international customs that became so entrenched that they became things that were sacrosanct and functioned like international law. In the 1960s, a lot of customary international law related to diplomats got codified by states in formal treaties and conventions. Similarly, rules governing salvage of shipwreck materials, right, is something that there was customary international law governing. A lot of that's been codified in international agreements since then. There's also judicial decisions and the writings of legal scholars. And as with all law, there are gaps, right? So the people who are writing laws, whether it's Congress or whether it's a convention or a treaty, people don't always anticipate different situations or scenarios or all the gaps and possible twists and turns along the way in applying law to the real world. And that's one of the roles played by judges, is to listen to various different arguments, to consider the intent of those who are drafting the law, to consider the details of the situation, and say, here's our general principles of what we think is international law. How does that apply in this particular situation, right? And so if you have agreements that were put in place governing telegraph cables across the ocean, right, does that agreement then apply to fiber optics? Probably, but nowhere do fiber optic cables show up in those past agreements. Judicial decisions can help to extend the scope of some of those agreements to figure out where they apply and where they don't apply. And so judicial decisions end up becoming really powerful parts of making international law because it takes sort of what we think we know applies general principles of law, maybe past experiences, and helps to refine and make functional that law. Right, and it will set precedents for how agreements will be settled in the future, and can change how states understand and apply treaties and customs and other sources of law. And then a final source of international law is the statements that are passed by international representative bodies. And so I'll give you maybe two different examples of this. International organizations like the United Nations General Assembly will regularly meet, and they will discuss, and they will draft documents, statements and assertions about what should be happening, or what they would like to happen, or what rules they think should be in operation in the international system. The resolutions passed by intergovernmental organizations in and of themselves don't have any legal weight. They are oftentimes symbolic. They're oftentimes there to coordinate. The one exception is the UN Security Council. And we'll talk about when the UN Security Council has the power to act in a way that fits within the idea of international law. But most of the time, these resolutions don't have that kind of power. They're symbolic. Does that mean that they're meaningless? No, it doesn't mean that they're meaningless. In part, it helps to understand the international consensus. It can help to clarify things for legal scholars and for judges. And it can lay a track record that can help to work toward and build toward customary international law, right? And so there is this idea that you shouldn't be changing territorial borders by force. This is something that's one of the core principles behind the United Nations system. If the General Assembly is passing resolutions every single year, calling out efforts that have changed territorial borders by force. For example, Russia's annexation of Crimea, right? That further reinforces and reentrenches this idea that this is outside the bounds of acceptable behavior, and further entrenches this as customary international law because we have this built-in track record. I'll give you a quick little example of different ways this can work and how these things can fit together and be operating side by side. And so I'll start with some of the as I guess a case study on just war, which has a customary law component, right? And so a lot of what we think about when we think about just war is based on sort of the Western tradition of how Christian states are supposed to conduct themselves in a way that's consistent with Christian values. And this is something that St. Augustine spent a lot of time reflecting on and writing about, and became sort of the foundation for the Western tradition of the just causes of war, or jus ad bellum. The J and the jus ad bellum it's Latin, so I guess it gets pronounced with a Y. And Augustine and others who refined his thinking have argued that for a war to be just, it must be fought as a last resort. Right? You can't rush into war. You can't, launch a preemptive strike. We'll get to that. But that it should be something that you do after you've exhausted all other possible options. Secondly, a just war should be waged in self-defense. Right? You shouldn't be the one initiating the conflict. You should be defending yourself. You can also defend the defenseless. So potentially when Iraq invades Kuwait in 1990, the international community's response could be considered a just war, in part because it is a larger international community responding to the needs of a weaker state attacked by a stronger state. Then there's the question of preemptive war. Preemptive war is where there is a army marshaling on your border, and a spy stumbles in out of the rain and says, the attack is coming tomorrow. And you do the calculation, say, if we absorb that attack, we'll be destroyed. But if we strike first, we're going to be able to survive this. In that circumstance, right, that's very narrow circumstance, you can say this is a just action, according to Augustine and other theorists of this. But that's different than preventative war. Preventative war is, there's an adversary out there that might attack me at some point in the future. I don't have any reason to believe that attack is coming tomorrow. I don't have any reason to believe that attack is imminent, but I anticipate there'll be a conflict at some point, and things look pretty good for me right now, so I'm going to attack. That would not fit within the logic of just war, because that would be violating the idea that it's fought as a last resort. Um, there's also this idea that war should be undertaken by a legitimate authority. When Augustine was writing, he was differentiating why it is that kings can authorize violence and killing versus the everyday individual, you and I. We're not allowed to conduct war. There's this idea that we don't have that legitimate power to make those determinations, but the state does. You could also argue potentially that the United Nations Security Council now has that power to determine whether or not force is being used in a just way, and to authorize and legitimize the use of force. And then lastly, war should be fought to bring about peace. You're not fighting to get more territory. You're not fighting for a better settlement. You're fighting so that you can stop fighting. And when that opportunity for peace arrives, you should take it. And if you refuse to take it, then perhaps you're not actually fighting a just war. So this is sort of how Augustine has squared that circle. And it has sort of filtered down through the years as the sort of expectation for how states ought to act. A lot of these elements have been incorporated into the UN Charter and into the operation of the Security Council. And so I think that there's certainly evidence that states have believed that this was the way that things ought to be, right? There was a sense that has that sort of condition of opinio juris, that I am obligated to hold to this. But there's also a lot of law governing war that's not custom, that's actually codified in actual documents. And so a lot of the international law governing war focuses on jus in bello, the just conduct of war, how you carry yourself when you're actually fighting a conflict. And so those kind of things tend to focus on this idea of being discriminate between civilians and combatants. And there's this idea that you should not be directly targeting civilians. The Geneva Conventions lay this out. There's the sense that you should be able to determine who you're actually targeting. So there's been a lot of effort to ban landmines. In fact, virtually every country on the planet has signed on to a convention banning landmines. Part of the reason for that is that a landmine doesn't know who stepped on it. A landmine will blow up whether it's a civilian, or it will blow up whether it is a combatant, and therefore you can't sort of have that idea of a distinction between combatants and civilians, right? And so there's other things that sort of go into this. There's this expectation that war should be fought out far away from population centers by armies that are dressed in identifiable uniforms and marching in formation, and all that stuff is great, but that doesn't look like modern contemporary conflict, where oftentimes things are in a population center and the line between civilian and combatant can get very blurry. And so how that actually plays out is something that gets regularly debated and discussed by international legal scholars, by the international justice system that we'll talk about, and by military planners and strategists. There's a variety of other laws of war. The Geneva Conventions lays down a lot of these things related to how prisoners should be treated, related to what kind of weapons are admissible in the battlefield, related to the use of torture and other sorts of things. And then there's also this idea that's really central to a lot of rules of international law, and that is that in order for your conduct in warfare to be considered just, it should be proportionate, right? And what that means is that you respond more or less in kind, an appropriate response rather than escalation. And again, I think the idea coming from Augustine is that war is terrible. War is the aberrant state, and we want to get away from that as soon as we can. And so if there's a raid across your border, you don't respond with a nuclear weapon. You might respond with a raid across a border in turn, and that will keep the conflict and destruction at the lowest level possible. And so this is something else that gets codified in different places about trying to not engage in wanton destruction, to try to minimize the cataclysmic effects of war, don't target cultural sites, those kind of things, so that we can retain some sort of sense of proportionality in how we engage in conflict.